Bismillahirrahmanirrahim. Viewers, our today's video is on ultimate beneficial ownership. In this video, we try to highlight and explain that who is beneficial owner and who is ultimate beneficial owner, its definition, and other different legal questions in the context of ultimate beneficial ownership. So viewers, first of all, we discuss who is an ultimate beneficial owner of a company. Ultimate beneficial owner means a natural person who ultimately owns or controls a company, whether directly or indirectly, through at least 25% shares or voting rights, or by exercising effective control in that company through such other means. I once again repeat, ultimate beneficial owner means a natural person who ultimately owns or controls a company, whether directly or indirectly, through at least 25% shares or voting rights, or by exercising effective control in that company through such other means. Viewers, before we move forward, kindly subscribe our channel for latest updates on taxation in Pakistan or different company forms, their filing, and other law related videos. Kindly subscribe our channel please first. Now we move forward. The next question is the definition of ultimate beneficial owner the same for the different type of legal persons? Viewers, legal persons are legal entities that are formed and established through a law. Such a public company and private companies registered under the Companies Act 2017. Limited liability partnerships registered under the Limited Liability Partnership Act 2017, and cooperative societies registered under the Cooperative Societies Act 1925, etc., etc. Now, the definition of ultimate beneficial owner is different under the different laws, keeping in view the unique characteristics associated with each type of legal person. For example, Section 123A of the Companies Act 2017 defines a ultimate beneficial owner as a natural person who ultimately owns or controls a company, whether directly or indirectly, through at least 25% shares or voting rights, or by exercising effective control in that company through such other means. But Section 8 of the Limited Liability Partnership Act 2017 defines ultimate beneficial owner as a natural person who ultimately and effectively owns or controls a limited liability partnership through direct or indirect rights, or who shares at least 1/4 of the net profits and losses of their partnership. The threshold of ownership or control for the purpose of classification as an ultimate beneficial owner provided in the definitions in the different laws and regulations is the same, that is 25% or 1/4. Now the question is, how would you differentiate between direct ownership and indirect ownership of control? Viewers, direct owner refers to individuals and entities who directly own shares in any legal entity. For example, if you own 25% of the shares in a particular entity, you become a direct owner. A direct owner need not necessarily by an individual, that is natural person, and can also be another entity, as in the case where the parent company is a direct owner in its direct subsidiary. A person can be an indirect owner if a company or any other business entity in which he has shares owns another company. For example, if company 2 is owned to the extent of 25% by company 1 and company 1 is owned to the extent of 50% by a natural person, then the said natural person is an indirect owner of company 2 through company 1. The effective ownership of the person in company 2 through company 1 will be 12.5%. Now the next question is, how would you differentiate between beneficial ownership and legal ownership? Viewers, ownership is the right to possess, use, sell, donate, or give as a gift any asset or property belonging to a person known as the owner. An owner can either be a beneficial owner or a legal owner. A legal owner is essentially the official or formal owner of a property. The legal owner of an asset may either be a natural person or a legal person that holds the legal title of that asset. But on the other hand, a beneficial owner is the person with the right to enjoy or benefit from the property. This can include the right or entitlement to any income from the property. In majority of the situations, the same person is the legal owner as well as the beneficial owner. A beneficial owner must always be a natural person, as a legal person cannot exert ultimate control over an asset or entity. This is due to the fact that legal persons are always controlled directly or indirectly by natural persons. Viewers, the next question which came into mind, that does every company and limited liability partnership has to prepare a register for ultimate beneficial owner? The answer is yes. Every company and every limited liability partnership has to prepare a register of its ultimate beneficial owners and shall timely record accurate and updated particulars in a timely fashion. I once again repeat, every company and every limited liability partnership has to prepare a register of its ultimate beneficial owners and shall timely record accurate and updated particulars in a timely fashion. Now, where are the ultimate beneficial owners detail required? Important question. Viewers, each company shall identify and obtain the ultimate beneficial owner information within 3 months from the date of coming into force of Section 123A of the Companies Act 2017, that is commencing on 26th August 2020. Similarly, every limited liability partnership shall, within 3 months of coming into force of amended Section 8 of the Limited Liability Partnership Act 2017, that is 27th of August 2020, take reasonable measures to identify and obtain the information of its ultimate beneficial owners. Now, the mechanism to identify and obtain ultimate beneficial ownership is a comprehensive mechanism to identify and obtain the ultimate beneficial ownership. Information as well as requisite forms are provided in the company's General Provisions and Forms Regulation 2018. Similarly, mechanism for limited liability partnerships and foreign companies are provided through amendments to the Limited Liability Partnership Regulations 2018 and Foreign Companies Regulation 2018 respectively. Every incorporated company and registered limited liability partnership shall have to provide a declaration of compliance to the registrar with the requirements to obtain, maintain, and update ultimate beneficial owners information. In case of a listed company, a copy of the said declaration shall also be filed with the Commission, that is Securities and Exchange Commission of Pakistan. Viewers, now what is the mechanism to register or cancel the bearer shares or bearer share warrants? A very important question. Lots of viewers asked about that, the mechanism to register or cancel the bearer shares or bearer share warrants. Viewers, a comprehensive mechanism to register and cancel the bearer shares or bearer share warrants is provided in the company's General Provisions and Forms Regulation 2018. You can easily access there in the 2018 regulations of the companies, where a detailed and comprehensive information is provided there. Now, a very important question is, who needs information on ultimate beneficial owners and control? Viewers, ultimate beneficial owner information is necessary to detect and prevent tax evasion, corruption, money laundering, terrorist financing, and other illicit behavior involving one or more companies or legal persons. Public trust in companies and markets largely depends on the existence of an accurate disclosure regime that provides transparency in the beneficial ownership and control structures of companies. Ultimate beneficial owners information assists financial institutions in applying adequate customer verification procedure before commencement of the relationship with their customers. This is also likely to assist the companies themselves in undertaking their ultimate owners controllers, where there are complex corporate ownership and or control structures. Viewers, different authorities may have a recognizable legal interest in obtaining information on ultimate beneficial owners and control in order to investigate suspected illicit activities. Law enforcement authorities investigating and prosecuting money laundering and other crimes, tax authorities verifying compliance with tax laws, and securities regulators investigating market manipulation, unlawful insider trading, and fraud are just some of the authorities who may require information on ultimate beneficial owners and control. Viewers, courts may also need such information in the context of litigation cases. Legal and beneficial ownership information can assist law enforcement and other competent authorities by identifying those natural persons who may be responsible for the underlying activities of concern or who may have relevant information to further an investigation. Now, another question: what are the requirements for provision of ultimate beneficial owners information to regulatory authorities? Viewers, companies and limited liability partnerships shall also provide this information to any other authority or agency of the government pursuant to the powers to call for information entrusted by law to such authority or agency. Each company and limited liability partnership shall authorize its chief executive officer or designated partners or one of its directors, partners, or officers to provide the requisite information to the concerned authorities and provide further assistance as may be needed. Now, another question which comes into mind, that what is the difference between a member and a shareholder? What is the difference between a member and a shareholder? Where a shareholder is a person who owns the shares in a company, whereas a member is a person whose name is entered or recorded in the register of members maintained by the company. The name of a person will be entered or recorded in the register of members in the capacity of a subscriber upon registration of a company, and later if any person agrees in writing to become a member of the company. Every member may not be a shareholder, and likewise every shareholder may not be a member. Now the question arises, is there a need for filing a nil Form 45? Declaration of compliance with the provisions of Section 123A of the Companies Act 2017 in case of a Section 42 not-for-profit association not having share capital, or which is not having any member having at least 25% voting rights in the company? The answer is every company, including a Section 42 company, is required to issue a notice to every member who directly holds at least 25% of shares or voting rights in the company, or to the representative of every legal person or legal arrangements which holds at least 25% of shares or voting rights in the company. Further explanation of Regulation 19A of the Companies General Provisions and Forms Regulation 2018 specifies that a member or a natural person may be classified as ultimate beneficial owner by virtue of exercising control through other means, which may be exercised inter alia through close relatives or associates having significant influence or control over the finances or decisions of the company. All the companies required to issue notices as per Form 42 shall file declaration on Form 45. I once again repeat, all the companies required to issue notices as per Form 42 shall file declaration on Form 45. Now, is a company required to file Form 45 with the registrar together with annual return of the company after its annual general meeting, generally we speak as AGM, or required to file Form 45 with every change occurring in ultimate beneficial owners of the company during the year? Viewers, a declaration of compliance in pursuance of Section 2 of Section 123A of the Act as per Form 45 is required to be filed with the registrar concerned within 15 days from the receipt of declaration under Regulation 19A2 of the Company's General Provision and Forms Regulation 2018, and thereafter along with annual return of the company under sub-regulation 5 thereof. For any change in the particulars of ultimate beneficial owner subsequently, Form 44 has been specified for the purpose under sub-regulation 3 of Regulation 19A. Viewers, if company B holds more than 25% shares in company A company B is further owned by the company C and D and individual E in such a way that shareholding of each of the companies C and D and individual E is less than 25% in company A. Now the question is, would the companies C and D and individual E qualify for the ultimate beneficial owner of company A? The answer is no. The companies C and D and individual E having less than 25% indirect shareholding in company A do not qualify for ultimate beneficial owner of company A through company B. Viewers, I hope you understand regarding the Form 45 and the meaning of ultimate beneficial owners in reference to context of the limited liabilities partnership and with regards to the Companies Act 2017. If you like this video, kindly subscribe our channel for lots of many more videos on the subject and other legal matters. I am really grateful to all of you who appreciate our efforts and to promote our channel, and I am very thankful to all of you for your comments and sometimes a very loving comments. I really appreciate these comments. Once again, thank you so much for your kind patience and for your listening this video. Thank you so much.